what we're doing and how we're doing. Oops. So shortly after the pandemic, the jury folks, and Michael can explain the details to it, we all determined that in order to bring the fewest number of people into the courthouse that we could, because as you all know, during the pandemic, less is better, that we sent out a COVID questionnaire to the jury panel. It was about, I don't know, Mike, about 20 questions, I think, give or take, where we asked about COVID status, vaccine status, but we then went a little further and also asked about hardships. So needless to say, we got a lot of parents that talked about needing to be home because their kids were being schooled at home and whatnot. And then we also asked the open-ended question, is there any other reason that you seek to be excused? And we got an array of them. Some were laughable, some were really upsetting in terms of people's comments. But what it did was it allowed us to pre-screen the pool. The clerk's office reviewed all of the, and it also told them the 2-week period that they might be on trial. So they knew their dates as well. So we did get a lot of excuses about, I have a vacation, I don't get paid, I can't do 2 weeks out, whatever it happened to be. And clerk's office would review all those, make a recommendation to me. I went through every one of them for the last 2 years, and we either added them to the pool, we excused them, or we postponed them. And so I don't see anyone on here that did a trial during the pandemic with us, is there? No. Okay. Steve, did you? No, Steve didn't do it. Anyway, we were able to call far fewer people into the courthouse in order to get a full jury pool. And the truth is, I think we used, so in a criminal trial is 28 jurors you need to get to 14. In a civil trial, Michael, what is it? How many do we need? 8.
We usually need, depending on what the panels would be, like 14 if 14. We're getting for 8. Yeah.
So we were able to call in like 30 people to get 14. So it reduced calling people in. It's cost effective, and it was an incredibly efficient way to do voir dire. We are contemplating, and the judges are going to have on our judge agenda, how and to what extent we proceed with this procedure. And in terms of how we should go forward with screening and questioning. And I think this is, Michael could tell you a little more of the details before, but I think it's on the agenda for this committee to throw it out to see what people think about it, what people think about continuing it, what people think about tweaking it, or whatnot. So Mike, do you want to just give a little of the details of how the procedure worked, and then we can open it up and people can let us know what they think?
Yeah, sure. So I think maybe the first thing to kind of understand is what we were doing before all of this. Normally what we would do is that we would send out a bunch of jury summonses. We tell people to show up on a certain date, and for many of you, as you know, you would just deal with these incredibly mundane requests of, I have a vacation on X date, or a doctor's appointment, or that kind of thing, which led to the kind of interminable line of sidebars in sort of dealing with small excuses. We found with this current process, as Judge McConnell indicated, that the pools were just much cleaner. Like we kind of got down to the meat of what every case was about. Like if there was, some particular issues that were of a substantive nature that really needed to be raised during voir dire, that we could focus on that and really get people in. So these supplemental questionnaires, and just so you understand, for every one of the trials that we did, we supplied all of the supplemental questionnaires to the attorneys, so they had them going into the trial. So you all, when you were coming in for a trial, are much more knowledgeable about who your jury panel is in front of you. I think that
we did that only for the people we did not excuse. Right. That was part of the thing I think people should understand, is that we did the excusal on our own, whereas the excusal used to take place in the courtroom in front of everybody.
And actually, one thing I can point out, and while we did, especially during the beginning of the pandemic, when we had obviously a lot of people, when we did trials in September of October last year, expressing concerns about coming in. This is obviously pre-vaccine, and we did have a lot more people who were concerned about serving. Is that our actual excusal rates weren't that much different than pre-pandemic. We just were it was a lot more of postponing people to a point in which they may have been more comfortable sort of serving. And also, like I said, kind of eliciting these types of things we would deal with on this sort of impanelment day. So like Judge McConnell said, the pools that came in were just much cleaner in terms of dealing with some of kind of that upfront stuff. So.
Like, how many jury trials were conducted?
So we did what, 5, I think, 4 or 5 in the fall, and we did 1 criminal one and 1 civil one in the spring. So I think that we've done 6, maybe 7 post-pandemic.
That sounds about right.
Yeah, and those are jury trials.
Which is actually more than we
Right.
normally do. I don't know if there's a cause and effect there in terms of the pandemic causing it, but yeah, we've had more jury trials in the last year or so than we've had in eons around here. But the jury selection process goes incredibly efficiently. I think on the criminal trial, I think Judge Smith told me he did the criminal case. I think he told me that what we do is we also random number them. So for those that have done jury trials in federal court, usually, we call in 50 people, all their name goes in that old style barrel, kind of like you saw Rittenhouse yesterday do it, if you watch the news. We'd put all the jurors' names in there, they'd spin it around, and we'd call out the first 28 in a criminal trial, 16 in a civil trial, and they go in the box. Instead, we now give them a random number before they come in. And so the first 28 numbers who are randomly selected go into the courtroom. The others who will not be in the box, who usually sit in the back of the courtroom, go into another courtroom and watch it. Of the 28, Judge Smith only lost 1 juror. Only 1 had to be replaced. So the number of jurors we're calling in dramatically less. The number of jurors we're actually using, we can actually call in even less, but Michael has been on the conservative side just to be sure we don't screw it up and not call in enough. And it's been far more efficient. But I'm not really sure that the bar in general knew that was being done. And for those people that study jury selecting, it's actually a pretty big change. I don't think substantively it's a change. The other thing that we noticed, purely anecdotal, is that the jurors that actually came in appeared to be at least as, if not more diverse than our pre-pandemic jurors. In fact, I think we sat 1 juror, oh no, this was a grand jury, but same concept. I think we had 3 people of color on it, and I haven't seen a case in Rhode Island with 3 people of color in the federal court. I'm not sure I ever have until then. So it's purely anecdotal, but we've seen that. So I didn't know if we just wanted to put it on here. When we talked with Pat, we wanted to just be able to hear from the bar about what you think of it, what you think of the process, whether you like it, whether you don't like it, whether we should continue it, whether we should tweak it, whether we should change it.
Any questions, comments?
Great. I had a feeling we were doing everything perfectly.
We'll think about it and get back to you.
Yeah, no, that's for sure. Yeah, just, we're just going to hit you with a lot of information and ask for your input, and that's maybe not fair. But anyway, just know that that's out there if people have thoughts about it, or, and we can also, now that it's out there, we can bring it up at the next meeting as well if people want to have more in-depth discussion about it. And we'll also have more statistics by then too, probably.
Judge, this is Zach Mandel.
Hey,
Quick
Zach.
question. Hi, how are you? Is the supplemental question? I'm very much in favor of supplemental questionnaires, and I think this is a great idea. And our experience with supplemental jury questionnaires when they've been done by the parties has been that it expedites the jury selection process. So that's great. Is there anywhere that's accessible? Like the questions that are on the supplemental jury questionnaire? Is
We
that,
can put it up on the website, can't we, Michael? The standard form?
Yep, absolutely. I mean, we can show both what's on the kind of standard questionnaire that we normally use for jurors and then the supplemental one that we're currently using now. And like I said, some of them has sort of COVID specific questions, but some of them are more broad-based.
yeah, I would just be interested in seeing what's on there.
Yeah.
Because we spend a lot of time looking at this type of stuff.
Yeah, now realize, Zach, that it's not case specific because these go out well before we know which cases are actually going to be tried.
Right.
The dates are in there, which is huge because then people, first of all, they get in the mindset that it's going to be 2 weeks because that's what they're told right away. So we deal with all of the excusals because of time element. And then when they get there, you know, the average trial is not 2 weeks. So when you tell them it's a 4 or 5 day trial or something, I think they actually get a little excited about it and think it's great. The information that you get from it, other than COVID related, like, you know, I'm immunocompromised or whatever, that might be helpful to trial lawyers, is there the question of, is there any other reason that you should be excused? Right. And we have seen some rather obnoxious reasons. I'm sure people were thinking that was, you know, the more racist they were, the more they would get out of it. Little did they know that more racist they were, the more they were going to come in and sit here and wait. But other than that particular question, I think, Michael, unless I'm wrong, maybe a few questions about kids. There's not a lot more information useful in this for people that study picking juries.
Got it.
Per se.
Yeah, there's not that. I mean, actually, some of the other stuff will come from the standard questionnaire. So you get information about obviously where somebody lives and what they do for a living and what their spouse does for a living. That type of information is in there. Yeah, I think what Judge McConnell said is that sometimes people will use the most open-ended questions as a sort of larger platform to maybe explain some things about themselves that you may find useful. I guess I'll leave it at that.
That makes sense.
Okay, anyone else? All right, well, we will think about it and get additional data and maybe talk about it at our next meeting. The next agenda item, and this is one we could have many, many meetings, but it's entitled Outreach, Diversity, Inclusion, and Anti-Racism in the Courts. And I'm not sure who's going to take this one.
I think Judge McElroy, I appointed a committee about a year ago and Judge McElroy agreed to chair it. And so sorry to put you on the spot, Judge McElroy, but.
We have met a few times. We kind of were configured with the thought that, oh, we'll be in person again in another couple of months. So we've met remotely a few times. We've done a few things to try to figure out where we're at and where we want to go on those things. And we've sort of divided up internally our sort of buckets of interest to statistically, what have we done? A lot of that is criminal and it's sentencing, personnel, internal personnel, and then a bigger bucket, what we'll call engagement, which would be engagement with the bar and also the community. So one of the things we've talked about, and you know, we've just kind of gotten delayed and I think lagged in part because I haven't done what I should be doing, but also just because we're not back in person, it's really hard to have these sort of conversations. One of the things we talked about early on was sort of like what I would call a customer service survey to say, okay, what's your experience like when you walk into the courtroom? How are you treated at the door? How are you treated at the clerk's office? How did the judge treat you? How did, you know, and were you subjected to sexism, racism, homophobia, any of those things? Or even do you have the perception of that? So there's that kind of bucket. And then there's the community engagement, which is even more difficult because nobody wants anybody in their space at this point. But we've talked about doing some things to reach out to the broader community in the state so that the court is seen as a participant in the community and not necessarily a place that you just go to when things have gone poorly for whatever reason. So I know that in hiring within the court, we've done some, Nora and John Marshall have done a lot with trying to reach out more broadly and hire with an eye toward diversity. But I'm not sure what our next step is or should be to include with, the federal bar. I mean, we've done things like read certain books as a group. I think we have a group subcommittee planning, instead of a Christmas party this year, a holiday party. We're going to have like a cultural fair sort of thing within the court. But I'm not sure, Nora, maybe you can answer me. Maybe I'm not up to speed like I should be, but where we're going to engage the Bar Association. I'm not sure if we've discussed that fully or at all.
Well, I think we started doing that in the spring, where we reached out to different bar associations and met with them, the chief judge and myself, and I think you attended some as well, Judge McElroy, and just getting input and feedback from, I guess, constituents, you would say, that we don't normally hear from, who may not necessarily be frequent filers here in the court. And I think we started the conversation in the spring. I think there's many more conversations to be had, but I think we're headed in the right direction. One of the things that we'll get to at the end of our agenda, and I won't steal their thunder, but our co-chairs for the district conference have more to say on that. And I think next year in 2022, we'll have a big district conference focusing on that. So I think we will get much more engagement very soon.
Thanks, Judge and Nora. Let me open it up. Any questions or comments?
Well, I'm sure most of you, if not all of you, have read the Providence Journal piece last weekend about bias in the Rhode Island Bar. And I think it's something that we don't talk about because we're afraid to discuss it, because nobody wants to acknowledge that we all have biases. And so I think it's something that's really important to talk about, to recognize. I mean, any woman on this call who's over a certain age can tell you all about the experiences they had practicing law, especially in the beginning. And I'm finding from talking to younger people that a lot of that still exists, even though, I feel like we didn't do enough to sort of move the ball. I'm sure anybody who is a person of color can say similar experiences that way. So I think it's something that we all need to talk about and acknowledge, and just be open to the fact that nobody's perfect. We all have biases. And if we recognize it and we talk about it, we have a better shot of sort of building a better court system that doesn't reflect that sort of historical racism that we have in this country, and sexism and homophobia and all of those other things. So I think it's important to talk about. And that said, I've said enough. So
if I could add in about what the Rhode Island Bar Association is doing, because Judge Rika Sloan is chairing a committee on diversity and inclusion for the Bar Association. And as you probably are aware through the article, Justice Long has chaired a committee for the judiciary on diversity and inclusion. And so what we're trying to do is we're going to be trying, or in the future, looking into collaboration between these two committees. And certainly if the federal court is doing something, then, perhaps that ought to be included in the mix as well.
Definitely.
We are actively looking at all these issues.
Great. Thank you.
Thanks, Mark. Any other comments?
Pat, I think Jennifer Wood has her hand up, or she's smiling. I can't tell what those emojis are.
Okay. Hey, Jennifer.
I was smiling in real life and I had the hand raise emoji up. So thank you for recognizing me. Yeah, I was going to mention that we've had a number of discussions and also with colleagues in the law school about these two interesting reports that are now in our environment around issues. There was a report that the Rhode Island Supreme Court issued earlier this summer about the experience of unrepresented litigants in the courts that touched on many of these issues about unrepresented litigants feeling uncomfortable and not particularly welcomed into the state courts. And then the recently issued report from the Bar Association about the experience of attorneys in the court system. So seeing the confluence of those two reports and some very concerning, although I don't think shocking or surprising findings about some of the work that remains to be done. I love the idea of this court and us as participants in this court looking more broadly at those three engagements that are going on with the Rhode Island Supreme Court, the bars, examining some of these issues, because I think the survey certainly of Bar Association members, I found a lot of the findings to be familiar to me as a woman attorney who's been practicing for a long time, but was more surprised that many of those same experiences continue to be prevalent. So just also jumping in to volunteer that if this court is going to enter that conversation in some broader way, I think there's some really good work that's being done across the judiciary and the Bar Association already, and that it all kind of comes together with some good information available and work that's already been done to lay the groundwork.
Thanks, Jennifer. Anyone else? Okay, well, obviously very important discussion, and we'll continue the dialogue and look forward to the announcement at the end of the session. Next agenda item is introduction of new staff members.
Did we skip over one? I
We
think,
did. Yes, we did. Where is the court going in terms of scheduling of hearings post-pandemic?
I don't know. I'll tell just a very quick funny story. Speaking of the pandemic, I had a case where an unrepresented litigant came in early on in the pandemic and wanted a emergency temporary restraining order to open up the State House. Remember way back like a year and a half ago, like everything was closed, the State House was closed, the doors were closed. And at first, I got all excited. Oh, this is a great issue about public building and blah, blah, blah. Anyway, she wanted it open because by that Thursday, she needed to smoke marijuana in the rotunda of the State House so that the pandemic would end. And the pandemic would go on forever if she weren't allowed into the State House, in the rotunda, to smoke her marijuana. And I won't tell you what I actually thought, but I denied her motion for temporary restraining order, and thus the pandemic, because of that, has continued for the last year and a half. So I'm not a really good one for predicting where the pandemic is going, because I didn't realize I had it in my grasp to end the pandemic. If only I had opened the State House to allow pot to be smoked. Anyway. This is really intended, we don't know where we're going vis-a-vis remote hearings post-pandemic. I do know that the judges, we intend to begin to discuss this in January at our judges meeting. I do know most of us have pretty pro-remote hearing feelings in general. But I think we put this on the agenda to try and actually hear from you folks, hear from the bar about what they think about what role remote hearings, Zoom hearings in our instance, that's the platform we use, should have going forward. When, one option is when the public health people bless bless us and tell us it's safe again to gather masklessly in courthouses? Does that become the new old norm? Do we default to remote in civil cases because of how well efficient it's been? And we hear from lawyers how wonderful and efficient we are. I'm not talking about evidentiary hearings, those are different. I'm just talking about standard hearings and whatnot. Is there some hybrid of that? What role should the lawyers have in requesting it and whatnot? So anyway, it's really just kind of an open discussion from the bar about where do folks think we should be going post-pandemic when it's safe for us to gather again in terms of how we conduct hearings.
Judge, if I may,
Yeah, hey, Andy.
I would like to see video hearings continue for criminal matters because A, it's a lot more convenient for the lawyers not to have to come downtown if your office is not downtown. But my conversations with my criminal clients is that they prefer to do it by video. It's contrary to popular belief, they don't like the field trips. I mean, part of it, quite frankly, is because when they get back to the prison, they're subjected to full searches and it's not pleasant. So
let me add
whenever
this.
I haven't had one client disagree with doing by Zoom. I think it's a good thing.
Let me add this. First of all, I'd say 90 to 95%. We can't conduct a criminal hearing remotely without consent. And in our district, thankfully, I'd say 90 to 95% of the defendants in a criminal case consented to remote hearings. We had incredible cooperation amongst the criminal defendant community and amongst the criminal bar to do that way. We don't have the power. We cannot do it remotely without an emergency authorization from the Judicial Conference of the United States. The only thing that has allowed us to do criminal cases remotely is the emergency finding by the Judicial Conference. We don't know when that's basically the Supreme Court. We don't know when they're going to pull that emergency finding from us on the criminal matters. So I think we'll come to some decision about whether to keep it up or not if we can, but some of that decision on the criminal side is going to be out of our hands. On the civil side, however, we can do anything we want.
We've got a hand up here, Judge. Brainsky Levinson.
Hi, Judge McConnell, Eric Brainsky here. How are you?
Oh, I'm great. How you doing?
I'm doing well, having problems with my camera.
Oh, no worries.
Hello to everybody else. I hope everybody's doing well. It's an interesting question, and I have to say, I sat on a subcommittee in Bristol County Superior Court for this very issue of, how to continue remotely post-pandemic, and what context that should be heard in. I can't speak for the criminal because, as you know, I do a lot of civil, but my personal feeling and the feeling of a lot of the lawyers at the bar, all of them, in fact, that participated in that, was for any hearing of substance, they'd prefer to be in court if it's more of a status update or a formal motion or, maybe even like a pretrial conference, those sort of things that are more administrative and mundane. That's where remote really comes in handy. But I know my personal preferences and a lot of the preferences in Bristol County was, in person for anything really contested or of substance. And one of the issues that came up, and maybe it doesn't happen that much in the federal court, maybe it's on the state court level, is for the young lawyers, and I know I have a young lawyer working in my office a year and a half out of law school, to do a hearing remotely is a whole different animal from being in court, particularly federal court. I know how I felt the first time I was in your courtroom, Judge. And it was intimidating, but it was also a very good part of my career to feel that courtroom around you and being in a federal court. So that's my feeling is anything contested of substance in person as soon as possible, as many times as possible. If it's more of an administrative, non-contested thing, then sure, remote on.
Great. Thanks, Eric.
Thanks, Judge. Thank you.
Nicole Benjamin?
Hi, everyone. And
Nicole.
thanks, Judge, for opening up the dialogue on this. I think, from my perspective, I really agree with what Eric just said, and for several reasons. One, I guess before I say that, I should say that I think the conferences remotely have been wonderful. So that has gone really well, and it's been inexpensive for our clients for us to participate in conferences. And I agree with what Eric said about some of the more formal matters, the matters that can be disposed of pretty easily. But I agree in terms of substance. And I think, Eric took the approach on the younger lawyers, maybe perhaps finding the experience of it being challenging to argue in a remote environment. I actually think that, from my perspective, one of the great things that the court has done historically is given an opportunity to younger lawyers. When I think about what the Litigation Academy has done and how, from day one, I've always felt very comfortable in federal court because it was always so welcoming to be in person. And I worry about whether we're missing out on that right now for, some of our younger lawyers who don't have, haven't had over the past year the opportunity to observe, let alone, the opportunity to argue. And, I agree, Judge, at the beginning, I think you said, put aside evidentiary hearings. And of course, those would have to, I think, be conducted in person. But unless you're getting that experience, leading up to that, I think that would be quite challenging for somebody who has only appeared in a virtual environment and hasn't had that, opportunity to be in the courtroom.
Great. Thanks, Nicole. What?
Can I add on that, Your Honor? So, I think a large part of the development of lawyers, young and seasoned, is the camaraderie that exists when we all convene in a courtroom. And we talk not just about the case, but we talk about each other, other cases, each other's families, what's going on. And we've kind of missed out on all of that over the past year and a half. So, Nicole and Eric hit it dead on. I mean, being in the courtroom, we all have the nervous jitters, and just to get back there and experience the courtroom, otherwise these courtrooms are going to become like ghost towns. And I understand, and I know from a client perspective, and we have to keep this in mind as well, it's far more convenient and less costly to the client to do remote hearings. But you also, part of the experience and the benefit that the client gets from the lawyer being in the courtroom, sharing those experiences, all is wrapped into the development to make us better advocates. So it all has to be weighed. And Judge, you can remember going to the motion calendar, and how much fun was that? And the defense attorneys would come back and we'd bill that hour or whatever, but we'd always talk about different things and learn from each other, seeing other attorneys argue and pick up tips from other attorneys. That's invaluable. You don't get that with remote. You have yourself and opposing counsel, but in the courtroom environment, you can sit in on a hearing and watch and learn. So I'm a big proponent. I miss seeing everybody. I miss the camaraderie. And I think most of you would agree with that. So that's my 2 cents.
Matt, thanks. Thank you. I don't, this isn't meant to disagree or to counter that. One thing we haven't talked about, however, is how much more engaged the public and or the bar public has been in our hearings. Like Pat, where's Pat Rocha? You were up, oh, there you are. Everyone keeps moving around on my screen. When's the last time we had 40 participants at a bench bar committee meeting, which is the number of participants we've had? I had a hearing about the consent decree in the United States versus Rhode Island case. We had over 100 members of the public watching on as we did it. So there's an aspect of that. I mean, we can only transmit video outside the courthouse during the pandemic authorization. And so we may not be able to do that again, but it is an aspect of remote that I think has been a big contributor to us being more transparent and being having the public and members of the bar more engaged. I mean, I've actually popped in on videos all over the country just to watch proceedings and other judges or what's yeah, I know, like Josh is rolling his eyes at me like I have nothing else to do just than to pop in and watch hearings. But no, it's kind of been fascinating to watch how other judges try a case or how a judge handles a particular issue. I watched a suppression hearing out in the Midwest the other day. And we've encouraged people here to do the same. I mean, you can go on our public website at any point and get the Zoom link to any kind of hearing before any of the judges and observe. Again, I'm not stating opinion one way or the other. I'm just throwing another fact into the mix as we think about how do we proceed from here.
Judge,
I do know this, we will never have another in-person Rule 16. I've heard every single judge say that they will never have another in-person Rule 16.
Can I say something though? Because, and I'm the newest judge here, and I only had a few months on the bench before the pandemic began. But I think one of the things that, and I agree that there is some camaraderie and some learning in just showing up in court and being there. But I think it needs to be balanced with remembering that we're also trying to be a little more inclusive. And so to the degree that we have either people who are disabled or people who have young children or elderly parents that they're responsible for, it may going forward be worth doing some things remotely so that you can have a more inclusive practice, so that everybody is not a person of a certain age who doesn't have childcare responsibilities or has really high quality childcare available to them. So I think that's something we need to consider, and I would ask people to consider that. I also think that, and I agree with Judge McConnell that we've had the experience of having so many people view things. I mean, to the point where with one of my recent hearings, we maxed out and I couldn't get on, which was kind of interesting. I thought I was able to go home and I was not, unfortunately. But while it's important to the development of the profession, and I think that that's where the balance comes in. Those of us who are of a certain age and can get to court and hang out and chat and all those things, that's great. But if you've got a 2-year-old who's throwing up at home and you're it that day, or if your elderly parent is sick, or if you're somehow disabled and getting out in the snow or the wind or the rain or whatever is difficult for you, I think that's a balance we need to think about as a profession. I would also say that while I think that Zoom can be more difficult, one of the habits that I've noticed is that people tend to read their arguments on Zoom, especially younger attorneys. And that's a really, it's a habit that hopefully that some combination of in and out of court arguments will break over time. So that's all I wanted to say, but thanks.
Thanks, Judge. Matt Parker, did you have a comment?
Hi, Pat.
Matt?
Yeah, I'll echo everything. I like having the remote hearings for the perfunctory stuff. And I think I miss them for the dispositive type hearings. And I definitely miss having in-person mediations. I mean, for whatever that's worth. I think having the mediations in person, something might be lost on the remote platform. But one other thing that I don't think anybody else has touched on yet is, in light of the fact that it's so convenient for attorneys to just click in, it wasn't that long ago when I was a junior associate, and it was more cost efficient to send me to court for some of these more minor hearings because it took all the time to go there and check in and wait your turn. Now that a lot of the hearings are on WebEx or Zoom, I've seen a lot more partners handling, stuff that might have otherwise gone to more junior lawyers and given them training and an opportunity to kind of develop professionally. And so I think in deciding a path forward, the court might want to weigh that a little bit too. I think that's one upside to doing some of this stuff in person, is that more people gain access to the court and experience doing these sort of, procedural hearings.
Thanks, Matt. Anyone else?
Yeah,
Yeah. Sorry.
Lynette had her hand up next.
thanks.
Oh, I'm sorry. I'm sorry.
No problem. Yeah, there's arguments both ways. I did an oral argument in the First Circuit. I had literally 5 minutes. I was very happy that I did not have to go all the way to the courthouse in Boston to speak for 5 minutes. On the other hand, I attended a Rhode Island Supreme Court argument about a week ago, and it was in person, and you really do lose something by doing them in the over the phone or just the oral stream. But I really want to agree wholeheartedly with what Judge McConnell was saying about the public. And some of this might be an issue with the limitations of the Supreme Court and the prohibitions on cameras in the courtroom and so forth. But to the extent that we can keep the courtrooms open both to the people who can come in person and to the people who can't, either because they're far flung or they have other things like disabilities or childcare or whatever. I know I couldn't get on one of Judge McElroy's hearings because I was the 360th person or something on the Zoom feed that was that well attended. And we don't see anything like that when it's just live. So if there's a way to blend the two, I think that it's really important for public access and public understanding of what the courts are doing to try to figure out a way to keep those. I personally like the video streams, but even if it's just audio, to keep those streams available in real time.
Barbara Hurst is next.
Maybe not. I think Brooks.
Okay.
Brooks had
This
his
turns
hand
out to
up.
be a follow-up to what Lynette said, but why does it have to be taken for granted, Judge McConnell, that when the emergency orders end, that the authorization for Zoom proceedings will be eliminated? And wouldn't it be time now, before that happens, for the particularly the district judges, but also appellate judges and the bar, the organized bar, the ABA, and whatever association you district court judges have, to start to lobby for a permanent rule that allows Zoom publication of even open court proceedings, and not certainly to wait until the pandemic, if it ever ends, results in a withdrawal of that permission.
Barbara, I'm not 100% sure I got the beginning part of the question, but
Well, Lynette was talking about the how good it would be if we could have both streams, if we had
Sure,
open
yeah.
courtrooms and also visual public streams of what's going on in them. And it seems you had commented that led me to believe that you expected that if and when the pandemic ever ends, that the authorization for Zoom proceedings will be taken away, or the ability will be taken away from individual courts or district judges. And I wondered whether there isn't now a movement, or shouldn't be a movement, by district court judges and the ABA and whatever other groups are interested in public access to right now start lobbying for a permanent rule that would allow streaming of court proceedings even when they reopen, if they ever do.
And Barbara, can I just 2 seconds? I don't know what the status of this is. And again, I'm most out of the loop, but I know there was a survey of judges, because I answered it, about how we feel about, maybe I'm the only one who answered it, but continued remote access to hearings. And I hope that everybody answered it similar to the way I did. Yeah, Nora is saying that, the administrative office. I answered that survey saying it should always be remote access. I mean, Why shouldn't, and I have, somebody who used to work with me, who's now one of my interns, who's disabled. So he can come to all my hearings now. He couldn't come to any of them if we were physically in court. And I think that even when we're physically in court, why shouldn't this be more open? So I agree with you, Barbara, but I think there is a push, and hopefully everybody, every judge answered that survey and answered it similarly to the way I did. But
trust me, having been on the chief judges conferences during the pandemic, not all judges agree with that. And certainly the Supreme Court does not agree with that currently. Whether we can lobby them to get them to change that, one of the things I've learned about the administration of the courts is it is the most slow-moving operation of any government entity I've ever seen in terms of change. So, those of us that are advocates, we're going to keep after it. We all can see the benefit of it, whether it's supplemental, like maybe Lynette and Barbara are suggesting, or another tool in our toolbox to assist lawyers in their practice. I don't know, but yeah, I mean, why aren't there cameras in the courtroom? I mean, this is the 21st century. Go figure.
But I think if I can just add a comment, that some of the aversion to cameras in the courtroom is an aversion to news broadcasters. Whereas the thing about the Zoom transmissions is that they're 100% controlled by courts, and that there may be different feelings because of that. At least I know that the Rhode Island Supreme Court's historic aversion to cameras was an aversion to really media coverage. And the idea that there would be snippets of little arguments on the evening news that really wouldn't educate anybody and would just be intrusive. So I'm not, there's no speaking for the US Supreme Court on any subject, but it may be that, as to some jurists anyway, some of the opposition would be less or eliminated when you're talking about court control of a steady stream of open proceeding.
Eric Bransky.
I think we keep missing Brooks. So if we can put him in the queue, I've seen his hand up for a while.
He's in the queue. He's next.
Okay, thanks.
Okay. Thank you, Judge. Thank you, Nora. I've encountered judges in other districts who have been doing as many hearings as possible live and keeping their courtrooms open. And part of the rationale they say for that is that there's been a huge amount of money spent and expertise gathered on trying to make the courtrooms, I won't say COVID safe, but COVID safer. And I know in our courthouse, Judge Smith has done a lot with Brown University, with engineers and architects trying to make the courtrooms a lot safer. So just recognizing that there's been this expenditure of public funds, there's been a lot of effort to make the courtrooms more appropriate in a pandemic environment. I would favor getting back to the courthouse as much as we safely can. I mean, I say that as a big fan of Zoom. It makes my life a lot easier, but just in terms of where we have put resources and what we've been doing, and Judge McConnell, you know better than anyone else, there's been a lot of effort put into making our courthouses safe.
You're 100% right, and Judge Smith was kind enough to take on the lead in making sure that we we're able to conduct a safe courthouse, a safe workplace, and a safe place for the public. And I'm proud to say we know of no transmission that has taken place at all in the year and a half in the courthouse. So yeah, thanks for recognizing that, Brooke, and that's a good point, Brooks.
Hi, Judge. Eric Bransky, at Eric Bransky. So I'm hearing what everybody's saying, and actually they kind of beat me to the punch, but I completely understand the inclusion part and having participants, and Judge, I agree with you in terms of cameras in the courtroom so we could have the public available to see what we're doing, lawyers, judges, bar. Perhaps, and I don't want to overstep my bounds here, but perhaps it makes sense to put together a subcommittee to examine this, maybe provide a report to the court, and then the court could use that report for whatever means it may be necessary, sending a report to the Supreme Court, Congress, whatever it may be necessary. I mean, I see both sides, and I'm anxious to get back in the courtroom. I agree with everybody's point, but I also see the point of having folks that can't get here, child issues. I know I have my own handicap folks, etc. That all makes sense, and I in one would be favor of that. I'd like to be a part of it if the court's willing to consider it. The only other exception being what Lynette said is if we could put an exception in there that has all remote hearings in Boston from now on. I'm good with that. And not having to travel up there, I am completely fine with an exception to the rule.
I know many an attorney in Warwick that feel that way about coming to Providence, by the way. I'm just saying, but
that's a Rhode Island thing.
yeah, Eric, I think that's a good idea, and I will bring it up at our judges meeting in January and let folks know if that makes sense to the body whole about putting a committee together to come up with guidelines.
Okay, great. Well, this has been a terrific discussion and one that will definitely continue. Next on our agenda now, introduction of new staff members.
Just real quickly, we've had some retirements during the pandemic and probably since we've last met. Paula Farrell-Pletcher in the clerk's office has retired. Barbara Barletta retired. Steve, who you probably don't know, but in the background in our IT department is retiring in January. Elisa Quartino retired this summer. And so because of that, we've had a huge shift in personnel here internally, and we've also hired 2 new faces that you might see or who might answer the phone for you in the front office. And that is Megan Kenny and Kayla DeCruz, and both of them are, Megan is an attorney. She's not a barred attorney, but she is an attorney, or she's a law school graduate. And Kayla has years of experience in customer service, and both of them are real good. Hopefully you'll meet them in person someday, but a really good addition to the clerk's office. And then Sahira Laura, who is in administration, she's doing our mail. She's also probably COVID tested you if you've come into the court. She's also a new member of our team. So hopefully you'll be able to meet them in the near future.
Let me just add it for folks that don't know, if for dealing with chambers, Ryan Jackson is now my case manager, replacing Barbara Barletta, who retired. Nishi is now Judge Smith's case manager, and Carrie Potter is now Judge McElroy's case manager. So that's the new lineup. I know for a lot of lawyers, that's the entree into the judge's administrative world. So that's the new lineup.
Thanks, Judge. And next we have the announcement on the 2022 district conference.
Yeah, I'm really, I'll turn it over to them in a minute, but really thankful that, or proud to announce that Jennifer Wood, who's the executive director of the Center for Justice, and Josh Xavier, who's an attorney at Partridge, Snow and Hahn, have agreed to co-chair the conference, which will be next October 2020. And Josh and Jennifer, I'll turn it over to you guys now.
Josh, why don't you go ahead and share your thoughts, and then I'll jump in behind you.
Hi, everyone. So great to see so many familiar faces. Thank you, Judge. And I'm very excited to co-chair the District Conference Planning Committee along with Jennifer. I'm really excited to work with Jennifer. I'm excited to bring this conference. The conference is planned to be in person. So I know a lot of you have made comments about missing seeing each other, building those relationships. So hopefully we can all see you at the conference next year in person, which we're really excited about.
I didn't state the exact date because I couldn't remember it, but is it October 22nd?
28th.
Yes.
October 28th.
October 28th. And it's going to be at the Marriott Hotel. The
On Orange
Omni
Street.
Hotel downtown was booked and we couldn't get in next fall. So it's going to be Friday, all day Friday, October 28th at the Marriott Hotel on Orange Street.
Thanks. I'll just say how much I joined Josh in the excitement on working on this committee and bringing forward what we hope will be a dynamic and engaging conference next October. I know that many of you will receive outreach from Chief Judge McConnell in the coming days to serve on the planning committee that Josh and I will be co-chairing. And spoiler alert, we'll be certainly turning to the full committee for all of their insights and inspirations about topics and panels, but we're really looking forward, consistent with the agenda item discussed earlier this evening, to bringing a focus on the role of the federal courts in expanding social justice as part of the conference in 2022. So that will be consistent with some of the work that was discussed earlier in our conversation this evening. We also want to make sure that there are some practical panels and issues around some of these very issues we've discussed about functioning in the federal judiciary post-pandemic. And I know that several people have thrown a yellow card that we're not really post here. So, you know, just kind of trying to adjust to the world that we're operating in. So we're hoping that there'll be a lot of good practical sessions for people to come and think about these issues of hybridity and how courts are operating, and also hopefully some really thoughtful and thought-provoking panels about the role of the federal judiciary in the realm of social justice. So really excited to get to work planning with a committee and to see everyone at the conference next year.
Jennifer and Josh, thanks. So I have one add-on to the agenda. Steve Richard, are you on?
Hi, Pat.
Oh, hey, Steve. You have an update on the Federal Bar Association?
Sure. Just very quickly, recognizing the time. I have assumed the presidency from Tim as the chapter president of the Federal Bar Association. And first, kudos to Tim for his real dynamic leadership of the chapter. I'm sure he didn't sign up for this deal when he ascended to the position 2 years ago, but he really held us together in a unique time and really did a lot of novel things that kept us going. So very briefly, we will most likely have our next meeting virtually the week of December 13th to put in place our new officers, many of whom I see on the screen. We've got a great team and we look forward to engaging with the court in 2022, lending our support as much as we can to the District Court Conference and all of the other initiatives, and really trying to build on our partnership with the bar and the bench to bring us all back together next year. So most importantly, check your membership status and call me if you have any questions. I know that sometimes renewals slip through the cracks when folks aren't in the office or don't get the mail as quickly as they used to. But just as importantly, in following up on one of Tim's initiatives, we really want to make our membership more diverse. We want to bring in a lot of the newer junior members of the bar. So please, reach out to us with ideas, programs, and mentorship possibilities to make us more inclusive and expansive, because that's really, I think, Tim's biggest contribution and one that I really want to build upon. So I'm here. Give me a call, shoot me an email, and we're looking forward to seeing you all next year.
Thank you both, Tim and Steve. I have a hard stop at 5, so I want to thank everyone. This has been a great meeting. It was great to see everyone, and happy Thanksgiving. And I'm going to sign off, but feel free to stay. Thanks, everyone.
Thanks, Pat.